And welcome, Employment Law Show. Good to have you along. John Scholes, Lior Samfiru. The reach out anytime, that is contact. 1-855-821-5900. Help at employmentlawyer.ca. We also do a long-running radio show, or I should say radio shows, Lior, and you can find those at employmentlawyer.ca across the country. Today on the show, rights of older employees during COVID-19. We'll drill down into that a little bit later on, but first, you always got something to say with the week that was. How you doing, pal?
I always have something to say, yes. When I don't, we'll probably stop doing the show.
That's right.
But until then, there's always a lot to talk about. There's always a lot of things to discuss when it comes to your rights, workplace rights, employment law, severance, losing your job, wrongful dismissal, constructive dismissal. We can go on, and we will go on. So if you want to talk and learn and understand your legal rights, this is the time, this is the place where we do that. We talk about those rights you may not even know that you have. Our jobs, everyone's job, have been impacted like never before over the past number of months because of COVID-19. But employment laws have not taken a hiatus. They're not gone. They're still here. They still protect you. And it's my job on this show and off this show to help you understand what those rights are, to enforce those rights as needed. So if you have a question about your rights that we didn't cover on this show, not a problem. We can't cover every topic in 30 minutes. So contact me after the show. Let's talk. Send an email. There's no bad questions. There's really only answers and solutions. So I look forward to speaking like I do every week with as many people as possible. But week there was. Let me tell you about a situation that came across my desk very recently. And this is not an unusual situation. I think many of you out there are going to understand and find yourself, or maybe you found yourself to be in a similar situation. So this person that contacted me had been working throughout COVID-19. They were fortunate that their job had not been impacted until recently. The employer told them that, well, now we're going to have to put you on a layoff, but good news, we've qualified for the wage subsidy. So you're going to be sitting at home getting the wage subsidy being for him 75% of what he was earning before. So very common situation. I bet you there's people right now watching us that have been in the same situation. So he called me and he wanted to know, okay, well, I'm assuming, Lior, is what he said, is that there's nothing I can do about that. They're paying me the wage subsidy, so I guess that there's nothing else here. But, I wanted to check. Well, no, not so fast. Let's forget about the words wage subsidy. It doesn't really matter where the money is coming from. What matters is that this person that used to make a certain amount of money is now only making 75% of it. He's taken a 25% pay cut. Whether it's because he's getting money from the wage subsidy or the company's paying out of their own pocket, it doesn't matter. He's taking a 25% pay cut. So what does that mean? Hopefully, our regular viewers know that if you're taking a significant pay cut, we're now then dealing with something called a constructive dismissal. If you're experiencing a pay cut, 25% pay cut is a huge pay cut, you have the right to treat that as a constructive dismissal. Now, that's true even if it's with the wage subsidy. Even if the 75% you're getting is through the wage subsidy, it doesn't change that. It doesn't really matter how or why the money's coming. What matters is, did you take a pay cut? So for this person and for anyone else that find themselves in the same situation, you have those options now. First option is, yes, you can continue you continue working, or you continue accepting the wage subsidy, and that's fine, and that's your new reality until something else happens. Or you can choose to treat this as a termination, constructive dismissal. You can choose to treat this pay cut, this wage subsidy, 75%, as a termination of your employment and get your severance based on 100% of your wages, not 75%. So that's the option. And this person is deciding right now what he wants to do. So I wanted to remind you there, if you're getting the wage subsidy, you do have the right to treat that pay reduction as a constructive dismissal, as a termination. The fact that it's the wage subsidy does not change the analysis in any way.
It's funny, you've often said, if you turn the tables to make it more clear that if it's a situation where the employer's just giving you a pay cut at 25% or putting you on a temporary layoff, which is 100%, you try and say, you know what, I feel like having a 25% increase in my pay. How about that today?
Yes.
You know the answer you're going to get.
Absolutely. And people have a hard time understanding that. They think that in the employer-employee relationship, somehow the employer has more rights to change the job. Well, no. Once there's a deal on your job, on your compensation, it's a deal. And it can't be changed. So as John said, just like you can't go into your employer and say, I've decided that effective Monday, you're paying me an extra 25%, so appreciate that. Thank you, man. No, you can't do that. If you did that, someone would look at you pretty funny. Well, by the same token, the employer cannot say, I've decided that you're making 25% less. A deal's a deal. In that respect, you're equal in this relationship, employer and employee. And if the employer does cut your pay, you have the option to treat that as a constructive dismissal.
The website is employmentlawyer.ca. If you haven't been there, spend some time, lurk around for a little bit. You'll find that you can find links to our radio show that's been running for some time. We play a ton of phone calls, or at least we get a ton of phone calls on the radio show, Lior, and we like to play them back here and dissect them a little bit more. First call for the day is coming right now.
I recently returned from mat leave with my company, and they want to change my shift. I don't have accommodations for the childcare for certain days of the shift. When I kind of spoke up about it, they kind of said you have 60 days to comply or they'll have to take further action. They're really pressuring me to take the shift, but I cannot. I was a Monday to Friday before my mat leave, and now they want me working weekends.
Ooh.
I mean, really, it's, again, I almost feel like just walking away and just shaking my head and saying, you know, what's the point if employers don't get these basic concepts? So there's three things here we need to discuss. The first is the fact that her employer has an obligation to bring her back after a maternity leave to the same job, okay? So if that job is available, if it's at all possible to bring her back to the same job, same hours, same days, the company has to do that. Otherwise, it's potentially a breach of the Employment Standards Act. It could be a breach of human rights laws. It's illegal. So right off the bat, there could be an illegal maneuver by not bringing her back to the same job. Now, issue number two, let's forget about issue number one for a second. Issue number two is that regardless of the maternity leave, her employer doesn't have a right to change her schedule this way, to change her from weekdays to weekends. That's a constructive dismissal. We talked about that at the beginning of the show. That's a significant change. If you work during the week, now your employer wants you to work weekends. That's a massive change. That's a huge deal. So you don't have to do that, and you can choose to treat that as a termination, as a constructive dismissal. So that's issue number two. Now let's forget about one and two. Let's talk about issue number three, and that is despite all these things, regardless of them, I should say, she has to be accommodated if she has childcare obligations. So if she does not have childcare on the weekends, or she can't work weekends, she needs her employer to accommodate her by allowing her to work during the week. Her employer has to do that. We call that accommodation based on family status. And if her employer refuses, that's a human rights violation. So I don't know that this employer could have done more things wrong if it tried. Human rights violation, constructive dismissal, breach of obligations on maternity leave, and more. So that's wrong. So she has a lot of options here. Her employer cannot make her do this. She has to be accommodated. She has to be allowed to continue working during the week. And if they do anything to her, I need her to call me and speak to me.
Yeah, this employer obviously hasn't strolled by the Employment Law Show merch table to see the Don't Mess With Mama paraphernalia, the coffee mugs, the T-shirts, now the face masks. I guess we're going to brand those as well.
Yeah, no, wrong. It's not rocket science when it comes to maternity leave. You have to bring back the person to the same job. That's it. And if you don't do that, there's going to be problems.
TerminationQuestions.com, another place for you to ask some questions when we're not on the air here, either on TV or radio. We'll get to our first ones. Mandavir writes in, says, guys, I just got fired from my professional role for over 20 years and offered only 4 months of severance. When I asked why it was so little, HR said they don't have to give me as much of a severance as they normally would because sales have been down during the pandemic. Is this true?
And I've seen this countless times, John, over the past number of months. Companies trying to use COVID-19, use the pandemic as a reason as to why they don't have to pay as much severance. So all those reasons are false. They're wrong and they're illegal. Your severance doesn't get changed because of the pandemic, okay? Not only does it not change, in fact, arguably you get even more severance because of the pandemic because it's going to take you longer to find another job. So whether the company is struggling or not does not remove their obligation to pay severance. Remember, your entitlements are based on a number of factors, including your age, your position, the length of your employment, and the likelihood of finding another job in the near future. All those are factors, not the company's financial situation. So to pay her 4 months after 20 years, listen, I'm going to be blunt, that's a joke. That's not even close. That's a wrongful dismissal any day of the week. Now, let's find out how much she's actually owed after 20 years. It's not 4 months. It's not even close. let's go to pocketemploymentlawyer.ca. You can go there yourself for your situation. So let's plug her information into pocketemploymentlawyer.ca and let's see how much she's actually owed. Again, not 4 months. So we know she's been there for 20 years. Let's say she's in her 50s. I don't have that information. You can see right there that she's actually owed anywhere from 18 to 24 months pay. 18 to 24 months pay, not 4 months. Depending on her salary, that could easily be a difference of more than $100,000. So no, this employer did it wrong. The good news is I'm going to get involved, and they're going to learn very quickly what they should have done, which is to pay the severance that they're legally owed. So no, COVID-19 is not an excuse for paying you less severance.
And we'll continue with COVID-19 as the topic after break. Rights of older employees during COVID-19. That is on the way. In the meantime, help@employmentlawyer.ca is the email address and the phone number. Anytime, 1-855-821-5900. Employment Law Show continues. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. John Scholes, Lior Samfiru. Lior, as we know, the aging workforce, there's more people working longer, earning more money, and sticking around longer to maintain their jobs. Some need to, some just want to. So want to get into the rights of older employees during COVID-19. How about that? It's a big topic now.
It is a big topic, and it's a big topic for a number of reasons. The main reason is a lot of employers now have to make decisions about cutting people, who we're going to cut, who we're going to keep, and how we're going to restructure our business. Most companies, if not all companies, have had to at least consider these issues since COVID-19 started. Well, the reason we're talking about this is because the company's decision as to who to let go cannot be influenced by a person's age. And I've been getting a lot of calls recently about people saying, well, they're not calling me back because of my age, or they're only calling back younger people. So we want to talk about the rights of older employees. Those rights apply always, but I think they're even more important to keep in mind now while we're dealing with COVID-19.
Sure, the first question, the obvious one, I guess, is can an older employee be let go because of their age?
And the reason to that, the answer to that, I should say, should be obvious. I really hope it's obvious. Absolutely not. We have human rights laws in this country, in every province, that prevent discrimination based on age. So your age, not only can you not be fired because of it, that age cannot even be a consideration in deciding whether to let you go. It's one thing that it's not, obviously can't be the reason, but it can't even be part of the reason. Maybe the company has 10 reasons to let you go. If one of those 10 is your age, that's illegal. That's a human rights violation. Your age should not be part of the analysis in any way, shape, or form, okay? You cannot be let go for your age. And by the way, that also applies to younger employees. If the company says, we think that people under the age of 25 are not reliable, so we're only going to hire people over 25, that's also age discrimination. Certainly it applies mostly for people that are older, but your age cannot be a factor whatsoever. And if you are let go because of your age, if you feel that you're not being called back to work because of your age, if you feel that your employer is giving you a hard time because of your age, all those things are illegal. You really got to reach out to me. Human rights laws don't have any leeway or any options for employers. They have to comply with them. If they don't, let's talk.
You know, we got a lot of employers that watch this show every week as well, and a lot of them are thinking, you know what, I got one or several employees that they're good. They've done a good job historically, but they're getting up in age and they're a little less productive than they used to be. What are the options there?
So first of all, an employer does have the right to expect the employees to be productive. As an employer, you should expect your employees to do the job that you hired them to do, and to do it well, the way that they've been trained, the way that they've been shown. And if you have an employee that's not doing a good job, you're allowed to engage in performance management. Meaning you can discuss the issue with the employee, you can put them on a performance improvement plan if you need to, you can even give them a warning if they're not doing a good job. Okay, you can't decide for yourself as the employer why that is. If there is an age issue or a medical issue, frankly, that's up to the employee to bring that up to you. And if they do, then you have to accommodate and be understanding and see if you can find a different role or a different way for them to work. But if you haven't been told anything about their age, don't make assumptions. You can performance manage the employee. And for the employee, if your job is being impacted because of your age or your medical condition, tell your employer. Don't just go to work and not do the job that you're supposed to be doing. That could come back to haunt you. So if there's a medical issue that limits you, whether it's age-related or not, tell your employer. Even get a doctor's note. That protects you. That ensures you cannot be punished. That ensures that your employer would have to accommodate you. So remember, the doctor always rules here. And as an employer, don't jump to conclusions, and you can performance manage.
Okay, now we'll flip it around. If I'm the older employee, don't say it, ignore the white beard. But if I'm the older employee and I realize, you know what, I'm starting to struggle, I feel a little uneasy, get a little embarrassed, what do I do?
Yes, and obviously that's not an easy situation to be in for any employee, but the best advice is to deal with it head on, okay? Not to try to avoid it, not to try to pretend that it doesn't happen, that you're not struggling, because you're not going to be able to do that. So how do you deal with it head on? Have a discussion with your employer. Tell them what the issue is. Make sure that they understand that it's not because you're being lazy. It's not because you're not trying. It's not because you don't care. There's an underlying issue here. Maybe you're slowing down because of your age. Maybe it's a medical condition. And even if needed, get a doctor's note. That ensures that your employer has to accommodate you. Maybe there's a different job that you can be doing that meets your limitations better and meets the company's needs better. That would be ideal. Maybe there's a way to change your hours of work or give you some assistance on the job so you can do your job. If you talk to your employer, if you tell them why that is, they can't punish you. You have that protection around you. Human rights laws do protect you. Getting a doctor's note always helps, as I said. Having the discussion helps. That's a much better approach than pretending that there's no problem when clearly there is one.
Talking about dealing with older employers during this COVID-19 pandemic, can an employer, or have you come across any employers that are starting to push the older employees to resign maybe because of COVID-19? You know, it's risky for you now, you're older, blah, blah, blah.
Yeah, oh, you really should be resigning. You know, think of your family. You can spend all this time, playing golf or, going to the beach or what have you. So you really should resign. I even had a case, you and I talked about this a while ago, where the employer started leaving pamphlets for the employee with, retirement homes and golf courses and what have you. But all of that is wrong. We can joke about that, but it's wrong and it's illegal. Telling someone they should be retiring, pushing them to retire, telling them that maybe they're not as welcome there as they used to be, that in itself can be a human rights violation. We don't have such a thing as mandatory retirement anywhere in Canada anymore. So you can work as long as you need to, whether it's 65, 75, or whatever the age is. You cannot be forced to retire. And of course, even being told or pushed or made to believe that you have no choice but to retire in itself is wrong. So tell your employer, I have no plans on retiring. If that changes, I'll let you know. And that should be the end of that conversation. If it's not, if you get pushback again, you may be able to treat that as a human rights violation, and we should talk. You shouldn't be pushed to retire. You can work as long as you want to.
If I'm an employer and I have a pool of employees that have been off for COVID-19, I'm starting to pull them back to work now. Can I cherry pick the younger ones over the older ones first?
Absolutely not. Not at all. No, no, no. And I've seen this happen a number of times over the past few months. No, your age cannot be part of the decision why your employer did not call you back to work. If the employer is clearly, as you said, cherry picking and only calling back the younger employees, that's a human rights violation. You should not be discriminated against based on your age. Whether you're 65 or 25, you should have the same opportunity to work, and your employer can't discriminate against you if they do. If you feel that the reason you're not working is your age, the reason you're still on a layoff and someone else isn't, is your age, we really should have a discussion.
The last question I'll ask is the one that we always say for the end, and that is, how much severance are older employees entitled to?
So remember the rule, and that is your age is a factor in your severance. The longer you work and the older you are, the more severance you're owed. So older employees, all things being equal, will get more severance than younger employees. So if you are an older employee, if you lost your job, regardless of whether it's COVID-19 related or not related, not only do you get severance, we know that because everyone gets severance, you're going to potentially get even more severance than if you were younger. Why? Well, the law says it may be more difficult to find a job if you're older, so we're going to help you out by giving you even more severance. The best way to find out how much you're owed, whether you're 65, 25, or 85, is you go to pocketemploymentlawyer.ca. When you go to pocketemploymentlawyer.ca, you'll see our severance calculator tool there. It allows you to find out in seconds how much you're owed, the actual amount of money or the number of months that the company has to pay you. It's easy to use. It's free. It's anonymous. It's accurate. You can check it out anytime on your tablet, on your smartphone, on your desktop. Just go to pocketemploymentlawyer.ca.
If you have not listened to our hour-long radio show before, go to employmentlawyer.ca, the website, to find a station near you. Pulling full call number 2 from the radio show, Lior, and going to play it back for us right now.
I've been being bullied from my owner. I've been intimidated, like the whole 9 yards. And I've had a lot of times where I've been verbally yelled at in front of customers. I feel like my rights have been violated. I feel like I'm getting less hours. Now, if you're being singled out, what can I do in those types of situations?
So I hope that even those out there that are not employment lawyers like me would know and agree that workplace harassment, workplace abuse is unacceptable. We all have a right to work in a harassment-free and an abuse-free work environment. That's simple. That's such a basic right that we all have, probably the most basic right. We cannot be abused. We cannot be mistreated or harassed in the workplace. Now, if despite what I just said, you have a boss, you have an employer, colleague, whatever it is that abuses you, that creates this poisoned work environment, then that's wrong. Now, number one is, is there someone you can speak to within the company to fix that problem? Can you speak to HR? Can you speak to the owner? If you can, you should. They have an obligation to deal with it. They can't fire you. They have to take it seriously and make it go away. If there's no opportunity to speak to someone, if there's no HR, or maybe it's the owner of the company that's harassing you, so who are you going to speak to? Well, then we need to deal with it externally. We can get you out of there. It's a constructive dismissal. It could potentially be a human rights violation as well, depending as to why you're being harassed. So no, you should not just sit there and take the abuse and have it impact your mental health, even your physical health. Not a good idea. You can do something about it internally if you can, externally with me if you can't. Either way, the law is going to be on your side.
All right, I want to grab another phone call from our radio show, Lior, but first we want to take a short break. In the meantime, you can reach out to yourself, 1-855-821-5900. TerminationQuestions.com is a great website, absolutely free and anonymous as well. Employment Law Show continues. Don't go anywhere.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. You're watching the Employment Law Show. John Scholes, Lior Samfiru. We also do a long-running radio show. Lior, phone call number 3 from that radio show. Let's play it back right now.
I work for an American company that's been bought out by another American company. I'm an independent sales rep. I just want to know if I'm terminated by the existing company, what am I entitled to?
How long have you worked total, including with the previous company?
8 years.
Exclusively for this company?
Yes. They would have to pay out by Canadian law or U.S. law.
Mm-hmm. So this is a very interesting situation. It comes down to, first of all, number one, is she in fact an employee or an independent contractor with this company? Now, if she's been there for 8 years, she's an employee. It's not even a question. You don't work likely for 8 years as an independent contractor. Most people are misclassified. Most people that think that they're independent contractors really, in the eyes of the law, are employees. That misclassification happens very, very often. If you look like an employee, if you act like an employee, you're an employee regardless of what you call yourself, what you signed, how you pay your taxes. None of that changes your actual legal status. Now, if she is an employee, if she loses her job as a result of this situation, then she's owed severance. Now, if the company that's selling the business is letting her go and she's not going to continue working with the company that's buying the business, then the company selling has to pay her severance based on Canadian laws as long as she works in Canada. And that's very important to remember, that if you work for an American company or even another foreign company, if you work in Canada, regardless of what province, it's Canadian laws that apply to you. If you work in Canada, Canada laws apply. The company can't say, well, we're headquartered in another country, so it's going to be the laws of the U.S. or whatever jurisdiction that apply. If you work in Canada, Canada laws applies, and that's important because, at least in comparison to the United States, in Canada, we have very good employment laws, regardless of what province you're in, and your rights are going to be significantly more. Now, this person, let's find out how much severance she's actually owed, because it's going to be Ontario laws or the province that she works in, those laws that apply. Let's go to pocketemploymentlawyer.ca and see how much she's actually owed. So 59 years old, let's say, and she's in a sales role, been there for 8 years. She's owed somewhere north of a year's pay, between 12 and 14 months pay is what severance would look like for her. Now, I bet you her employer doesn't appreciate that. They probably think, number one, it's U.S. law, so you don't get that. Wrong. Number two, she's an independent contractor. We don't have to pay severance. Wrong again. By the way, if you believe you've been misclassified, we talked about pocketemploymentlawyer.ca. We have a tool there, again, free and anonymous, that allows you to find out if you're an independent contractor for real or if you're actually an employee. So check out pocketemploymentlawyer.ca.
Yeah, you did mention the independent contractor thing. Now, she did say that's the only employer that pays her. That's the only source of income. Is that also a factor in determining that?
Absolutely. Now, the reason for that is an independent contractor is someone that, by definition, provides services to a number of companies. Right. So if you work for 10 companies, then you're probably an independent contractor, right? You have customers. You don't have an employer. Well, if you work for one company, they're the only ones paying you. Well, that's now an employment relationship. You're not really in business for yourself. You're an employee of that company. So if you work for one employer, you're generally going to be considered to be an employee of that company. By the way, the fact that you may work for more than one, that doesn't mean you're not an employee. You could still be an employee. But certainly, if you work for one company, that's going to be a huge factor. That's an indicator that you really are an employee and not a contractor.
See, I work for 3-4 different companies as a contractor, but those one company provides me with 60% of my pay.
Right. So we know an employee, we know an independent contractor. There's an in-between category called a dependent contractor. A dependent contractor is someone that does work for a number of companies, but they have that one big customer that pays them at least half of their pay. Because they're so financially dependent on that company, if that company lets them go, they're going to be entitled to severance from that company pretty much like they were an employee. So you may not be an employee and still be owed severance as long as you have this one big customer that you work for that decided to let you go.
There's a finite amount of stuff there, but you got to learn it. And anytime you need more information, simply call Lior. I'll give you the phone number again, 1-855-821-5900. We referred to it several times during the show today. That is pocketemploymentlawyer.ca. As you mentioned, there's a section on whether you're an independent contractor or not. The severance pay calculator is in there. Also a section on disability law. That website is completely free and anonymous. Again, pocketemploymentlawyer.ca. And finally, help@employmentlawyer.ca is the email address we use, so you can reach out to that anytime. We'll catch you again, the Employment Law Show. Thanks for joining us.
Thank you.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.